Case number 12.
My name is Richard Scheyer. I'm the attorney for the appellate respondent, Mr. Lewis, the homeowner, in this particular case. It's an interesting case, but it has two basic aspects, one of which has very far-reaching consequence. The initial case was in Article 78. The initial case was my client applied for a series of small variances for a home on Fire Island in the town of Brookhaven. The matter was heard with 3 very lengthy hearings in front of the Zoning Board of Appeals, after which, with evidence, witnesses, a lot of testimony, the variances... Excuse me?
The board granted 8 variances, correct?
Correct.
All right.
The board granted all of them and wrote a very long...
The court granted 1.
No, they granted 6 and denied 1.
I'm sorry. Correct.
And they found that 2 were not applicable because they were not structures based on, they interpreted the town code.
Right.
An Article 78 was then commenced by the next-door neighbors pro se. And as a result of being pro se, the Supreme Court gave them every consideration that I wouldn't have gotten. And we had 3 oral arguments on this particular matter. It stretched over a long period of time. At the end of which, excuse me, the zoning board gave them everything. The Supreme Court approved 6, denied 1, the fence. And in denying that, which is part of the issue, they created their own definition. He wanted a 20-foot privacy fence between bedrooms. It's a 200-foot long property line. And the court said, no, we're going to deny it because it's really not a fence, it's a wall. Well, there is no definition in the town code between a fence and a wall. He just created it. The reason was there was a lot of testimony, and the judge...
Who was he?
The judge, Judge Mayer. There was testimony by Judge Mayer, and it was a transcript that was so ordered, so it wasn't a simple judgment, that there was lots of precedent for having such privacy walls all over Fire Island, but since privacy fences, but since I'm calling it a wall...
Is it correct that Mr. Lewis did?
Excuse me?
That before the applications for the variances, Mr. Lewis wasn't so much concerned with precedent and what was permitted and what was not permitted. He built some stuff on that property because he wanted to build it without much concern as to whether or not it was consistent with...
Well, that's not totally true. Part of what he built was found not to be regulated. For instance, he had what they call a dry-laid slate patio. That means putting slates on the ground, no mortar, no cement. The zoning board found that under the town definition that's not a structure, and therefore it would not be regulated. He doesn't need a variance. A little pond that they had on the property, no pumps, no, just a little pond, also was not a structure and didn't have to be regulated. So 2 of the things that were there didn't fall under the code, and the zoning board interpreted it not to fall under the code. 2 out of how many? Excuse me? 2 out of 6.
2 out of 6.
Of the 4 that remained.
So there was 4 that he never really asked permission for, right?
No, he didn't ask initially, but he asked before they were completed. He wanted to put an extension on the bedroom. It hasn't been done.
That's the size variance is what caused all this to come to an end.
There were not big variances, just a couple feet. But that didn't become the main issue. The board heard it at length. They granted it. The Supreme Court said, except for the privacy section, which I now call a wall.
And I apologize for interrupting the flow of the argument. Do you see any problem here with the alleged conflict of interest here?
With regard to whom?
Chairman.
The chairman? No. I know all about the alleged conflict, and the attorney for the town knows more about it because he spoke to the chairman. But no, there really wasn't a conflict. I was the former chairman of the Islip Zoning Board, and in this case, is an attorney also as the chairman, and he had hired the firm, the environmental firm, to do a type 1 on a piece of property, and they did it and found that it didn't apply, and that was the total contact. Whether anyone you ever use in business grounds as a person, as a professional, puts you in a conflict situation.
How much earlier did he hire this attorney?
Well, we hired him maybe 6 months before this hearing, but the final report was...
Excuse me for interrupting you. Okay, you answered that question. And didn't the chairman recuse on voting on any other case where this person appeared at a hearing until then?
I don't know the answer to that.
Well, that's what the record seems to
indicate. It could be. It could be.
So doesn't it leave a bad appearance of impropriety?
Well,
This is the first case that he doesn't recuse?
Well, by that point, he had gotten a report saying he didn't need it, and he no longer was using his services.
You got an ethic, well, let me tell you, we have a 2-year rule here. But go ahead.
Well, I had a similar situation appeared in Islip. It came to this board. We were a 5-man board, not 7. There was a question of whether there was a conflict on something I had voted on, and the determination at that point by Judge Costello was it was a 5-man board, and whether the chairman voted or not, it was a unanimous decision. It was really moved because it wouldn't have changed anything. This was a 7-man board. They heard it 3 or 4 times. They voted unanimously on it. So whether or not that really created a conflict, I don't think it would have changed the outcome in any way.
Doesn't this change the character of the neighborhood, though? Let's go into the criteria.
Okay. The board found specifically, the zoning board, and this is their territory, they even made a personal inspection of the site, that this made no change in the character of the neighborhood, and they explained why in their decision.
Yeah, but they compared it to property before the regulations or the zoning
No,
rules?
not entirely.
No, not entirely.
Not entirely.
There's a lot of not entirely, not exactly, and not all in your argument.
Okay. I'll go back. Almost every one of the houses, a lot of them are older, have been changed and modified many times since they were originally built.
But that was there a code change, though?
The last code change there, I think, was 88. But the zoning board's aware of all those changes. This is something they're particularly familiar with. It's something they do all the time. They handle hundreds of these cases on Fire Island. But what happened is, after the matter got to the point of the Article 78, the respondents then decided that this should become an environmental issue, and that the real issue was that the National Seashore was not in favor of the application. Well, the National Seashore is not the controlling statutory body that controls land use and zoning on Fire Island. The 64 law that passed it specifically by the government gave that power to the local municipalities. Now, the question everyone asks is, why don't the zoning boards follow it? Almost none of them do. The reason is in here, if you read it, the standards that the National Seashore uses is completely different than the standards and the zoning codes of the towns. For instance, they're talking about percentage of lot occupancy. They would count those slates laying on the ground, but the town would not for lot occupancy. Heights, they use a different height regulation. So the towns apply their codes, not the National Seashore. I've had the National Seashore appear before the Islip Board, which has a lot of seashore. Many times when they're really interested in a case, they have the right under the code to condemn if they feel that something is really a problem. But what's being done more regularly, and that's why this is going to become a leading case.
It's just,
Yeah.
Pardon me 1 second, and I apologize for interrupting you, but you concede that there is the power to condemn once their standard is breached.
That's correct. That is the power that's given to them by statute. But what they're doing, instead of using the environmental laws as a shield to protect the environment, they're using it as a sword to beat down local regulation. And it's being done more and more. And that's why...
Who's using it as a sword?
Environmental groups. In fact, there's a motion pending here now by several environmental groups to put in an amicus brief on the grounds that you have to give controlling interest to the National Seashore. In fact, counsel's brief, in his first point, says the board failed to give compelling weight to the occupancy limitations of the federal law. Well, that is not a compelling argument because they don't have to. I personally have written hundreds of decisions with regard to National Seashore's objection and local government. If you take their position, you can't do anything because they're much more restrictive. The local ordinances are put in by the towns who have the authority, and the local boards administer them. They don't have the same test. Since you apply the local test, then you can't apply the Seashore's test. They're incompatible. So if you're going to say that the Seashore is going to govern what the towns do, that would be a landmark decision, completely different than anything that has occurred before. So what started as a zoning case has graduated itself into a question of whether or not the National Seashore is a compelling argument to a zoning board who stated in its decision, in each one of they went to 267, they said there was no environmental impact on each one of these things, and they explained why.
All right, but the environmental protection, they testified, right, at the hearing?
Yes.
All right. So even though the neighbors, they may have a self-interest, but the environmental protection, they basically said that this was deleterious changes to the environment.
Well, the National Seashore.
Yeah.
Yeah, the Department of the Interior. Yeah, but they always say that. I have hundreds of those letters that
So
they
should
send.
I always disregard them?
Almost universally.
I should disregard.
In fact, we have, in this motion to this board for a amicus brief,
So what is their function then?
well, they're advisory. They give advisory information, and they explain why they think you should follow their rule. But the reason they're rarely
Didn't
followed...
you just concede that they have the power to condemn?
They absolutely have that
So
power.
then how is that consistent with your statement that they're advisory?
Well, I take it back. They advise the boards. If they don't like the decision, they can condemn.
That sounds a little bit more than advisory.
It's more than advisory. However, I know of no instance where they have condemned improved property. I know vacant lots, but I never heard of them approving an improved house. They just don't simply do that.
You're asking us to disregard everything that they said. As Justice Fisher had pointed out, these changes were self-created in violation of various, maybe not all, you've made that clear, in violation of zoning laws. And now he wants the actions to be approved.
May I answer?
Sure.
The reason that you go to zoning boards 90% of the time is somebody has done something where they don't know whether they tripped over the code or not, and they're asking for the board to approve that and to say, yes, it's okay, we would have granted it had you asked us for it in the first place, which is really their test. And in this instance, except for the room, they haven't built that. We're talking about 2 decks that were the ones that were existing, and the board said they're inconsequential, they're not significant, and we would have granted them, therefore we're going to grant them now. And there's precedent for it, because everybody on Fire Island has decks, and they're all, nobody complies
But all
with
those
the code.
decks, that's what I alluded to earlier. I'm sorry. Do you want to go, Judge Master?
No.
No. All those decks were done before the change in the zoning code.
Not all, 2.
Out of
There's a
how
lot of
many?
decks.
Out of how many?
There's decks all around the building, but they're CO'd.
And they were, I'm sorry?
Most of them are CO'd. They're part of the old house, which has a certificate of occupancy.
That's what I'm saying.
The
They-
2 smaller decks that were added were done without an approval. And they were asking the zoning board for permission to leave them, which is what the zoning board does. That's why they're there.
We've asked you a lot of questions, Counsel. Is there anything else you want to tell us?
I think...
No, I'm asking you. Make
Well,
whatever
I think
arguments
that the general impact of the case has changed from a review of 267B as to what the zoning board did to what the authority of the National Seashore is with regard to zoning. It's going to have a massive impact on zoning boards all across Long Island, because if you take the position that they do, that it's a compelling issue if they oppose, and you have to consider it, and you have to write it up, and you have to say why you do and not agree with them, we'll have changed the entire landscape since
pun intended.
1964.
But the landscape, I mean,
Sorry, I didn't mean it to be a pun, but
No,
it came
I-
out pretty good.
you do recognize that properly, we would want to promote someone who seeks a change outside of the zoning code to make the application before it's done. That's optimal, isn't it?
Yes, but it's built into the system that the board must find, after it hears all the evidence, that there is no environmental impact, which they did, and why they don't find that. The question is, who makes the decision? Is the zoning board going to be an agency that can actually decide something? If they can't, then it's going to be done by an outside environmental agency. You can scrap the zoning board. You don't need them, because what they do isn't going to matter. And they're saying, we're taking the town code that the town legislature put in effect, we're interpreting it, which is their authority to do, and we're applying it. We're not going to apply something else from somewhere else, because that's not our mandate. And it has never been the position that they don't have any authority, and that's really what's happening here. So what started as an objection to the judge calling a wall and a fence the same thing, which isn't in the code, it has jumped where, if nothing else works, take an environmental argument, and now we're into a different twist to the case, which didn't exist before, and all of this dehors the record. It's all stuff that's coming up afterward. The entire 78 was full of new evidence being presented constantly. Of course, it was pro se people. They thought they could retry the case on the Article 78, but the basic decision of the zoning board was what was being questioned, and it went off into another field almost entirely.
Thank you, sir.
Thank you.
Good afternoon, Your Honors.